Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you. Before the court is Melvin Harris. In each of these matters, Mr. Harris is here today after failing to appear before this court on January 25th, 2023. In the first case, bond is currently set at $650. This is the fourth bench warrant. In the second case, bond is currently $500, and this is the seventh bench warrant. He reports no employment. Last payment made on these accounts was in December of 2022. Front of the court has been made aware that Mr. Harris currently has over $10,000 in his jail account. Front of the court recommends that reasonable bonds be set in each of these matters.
What was the time again?
8:00 a.m.
Okay, thank you. Mr. Harris, you're before the court charged with civil contempt of court duty or failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on April 26, 2023 at 8:00 a.m. You will get notice of that in writing. Sir, you have substantial money in your jail account. You should be able to, again, set the bond. Isn't that accurate?
Yeah, I could pay it. I could pay the two bonds today.
Okay. The court will continue the bonds in the amount previously set, and that will conclude the matter at 8:33. You're free to go. Have a good day, sir.
Mr. Lamont is here today after failing to appear before referee Jordan on June 27th, 2022. Bond is currently set at $815. This is the first bench warrant. He reports that he is employed at True Green. Last payment made on this account was in December of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 26th, 2023 at 8:45 a.m. before this court.
Okay. Mr. Lamont, you're before the court charged with civil contempt of court duty or failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on April 26, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Sir, I have no money. I was supposed to start this job at True Green this morning, so that way I could have had this issue resolved. I did contact the courts about a week and a half ago, and they told me it would have been $250 to take care of this bench warrant. I told them that within 2 weeks' time after I got my first paycheck that I was planning on paying that. Roommate got a hair up her butt and found out that I had a warrant in this matter and decided to take matters into her own hands. So that's why I'm here today. I have no income of any kind right now. Like I said, I was supposed to start that job today, and I would just like to try to get out so I can get to work and get this matter taken care of. I'm not trying to divvy out on my responsibilities as far as child support goes. I'm just trying to get back to steady employment. Around that time last year that I missed this court appointment, I was in and out of incarceration in Calhoun County due to another matter. So I don't know if it would have been one of those days that I was incarcerated there as to why I did not appear. But I'm not the type of person to not show up for court. Usually 9 times out of 10, I'm always there and I'm always early.
Okay. Well, if your first bench warrant, so the court is taking that into consideration. What I'm going to do, I'm going to reduce your bond and set it in the amount of $100. If you're able to post that, you can be released. Do you have any questions?
2392.
No, sir.
BP.
$100
Okay.
is fair
Mr.
enough.
Young is here today
Okay, thank you.
after failing to appear before referee Croteau on February 24th, 2022. Bond is currently set at $1,697. This is the third bench warrant. It reports that he is self-employed. Last payment made on this account was in February of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 26, 2023 at 8:00 a.m. before this court.
Thank you. Mr. Young, you're before the court charged with civil contempt of court duty or failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on April 26, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir. Today I'm not. I do want to get this matter taken care of, and my incarceration, and affects the children in this case, the most. I did recently make some payments and reach out to front of the court to try to get this warrant taken care of. I just wasn't able to make the payment. So.
Okay. Well, what I'm going to do, I do note that it is your third bench warrant, and you have, but I'll note as well, you recently paid some monies in February of 2023, so I'm taking all of that into consideration. What I'm going to do is I'm going to reduce your bond and set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. Court will conclude this matter at 8:38. Good morning to all of you. Mr. Matsura, I'm going to ask you first because you're the defendant. You've been submitted with a proposed judgment of divorce and a uniform child support order. Are you objecting or disputing anything, sir?
Do I have an opportunity to do that?
Well, I'm just asking you. I'm asking you if you are. Are you? Is there something you're going to object to?
About the full custody part, yes.
Okay. Well, what's going to happen is you're going to have to take action in this matter. There has been a default entered against you. You're going to have to seek to set aside that default. So you'll have to file a motion and then voice whatever your objections are. But court will basically hold the matter for 1 week. I won't enter it today, but hold it for 1 week. If you don't file anything within that week, then the court will enter the proposed judgment in the UCSO in this matter.
Understood.
And do you recall coming to my office in August of 2022 and signing a complaint for divorce?
Yes.
And in that complaint, you stated that you'd been a resident of the state of Michigan for at least 180 days and a resident of Calhoun County for at least 10 days. Was that true when you signed the complaint?
Yes.
And in the complaint, you stated there'd been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood your marriage could be preserved. Was that true when you signed the complaint?
Correct.
Does that remain true today?
Yes.
You and your husband have one minor child together. Is that correct?
Correct.
Are you currently pregnant at this time?
No.
Have you had an opportunity to review the judgment of divorce?
Yes.
And do you agree with the provisions contained within the judgment?
Yes.
And is it correct that neither you nor your husband are seeking spousal support?
Correct.
Do you understand that neither you nor your husband can come back to the court and seek spousal support in the future?
Correct.
If for some reason the judge were to not sign the judgment of divorce, do you believe there's any chance at reconciliation with your husband?
No.
May it please the court.
Court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. Court does find the file to be in order. A default was entered back on October 3rd, 2023. Judgment was properly submitted before the court. As stated previously, the court gave the defendant 1 week to take action in this matter. Again, failing to do so, the court will enter the judgment in this particular case. That will conclude the matter. You're not divorced until I actually sign that paperwork, so it still will take some time. And but best of luck to everybody, and hopefully we'll get this. Court will note the appearance of Ms. Podolsky on behalf of the defendant. This matter is before the court on the defendant's motion to forgive arrearage. Ms. Podolsky.
Thank you, Your Honor. The court previously entered an order in this case for as it relates to child support for giving arrearages from December 2017 through December 2020, as the parties were residing together during that time, and we had custody orders from another state that demonstrated that. However, the friend of the court has issued proceedings in this case here in Calhoun County stating that Mr. Mabbitt continues to be in arrears, and we presume that this amount is from prior to that December 2017 date. However, my client, Mr. Mabbitt, was in fact direct paying Ms. Hurd during that time. From January 2017 through November of 2017, he direct paid her the sum of $3,625. And then from March of 2018 through March of 2019, he direct paid her an additional sum of $4,600. This totals $8,225. As an offer of proof, we do have the records of the wire transfers during that time showing the direct payment. Because this was a direct payment and not processed through friend of the court and their income withholding, they were unaware of these payments. So we are asking that the amount that he direct paid, $8,225, be applied to the outstanding arrearage, which is currently $3,742.69. At least that's what it was as of the date of filing this motion.
Okay, thank you. Ms. Hurd, what's your response?
Your Honor, in 2017, there was an order for child support. Mr. Mavitt didn't pay me any money from January of 2017 at all. I
Okay,
don't even remember exactly when the order was put in for him to do child support, but when the order was put in, he had not paid a dime. And I think when the order was in, when everything was started, he owed like $6,000 some odd dollars in 2017.
okay. He's claiming in 2017 and thereafter that he paid you that $8,225 through direct pay, through wire transfers.
He never sent me any money in January of 2017.
Okay, well, what the court's going to have to do is be in view of that, the court's going to have an evidentiary hearing. The court will send the matter to the referee for an evidentiary hearing on the issue of the arrearages. You'll get notice of that, and then you'll have to appear at that time, produce all of the evidence that you have at that time. Anything else, Ms. Podolsky?
Nothing, thank you.
Okay, Ms. Herr, anything else?
Nope.
Okay, you'll get a notice of upcoming hearing from the referee.
Mr. Vanderhorst,
on behalf of the defendant, Ms. Podolsky, on behalf of the intervener in this matter. This matter is before the court on the intervener's notice for entry of modified UCSO. Ms. Podolsky.
Thank you, Your Honor. We were here previously. The court accepted the uniform child support order. However, the friend of the court did object. We had that order marked as a final order because there had been a prior support order between the plaintiff, who is now deceased, and the defendant. Friend of the court asked that we mark this order as being a modified uniform child support order. So that is what we have done. They have approved it, and we're asking the court to enter it today.
Okay, Mr. Vanderhorst, any objection?
No objection to the child support order being entered, Your Honor. My only concern is the Social Security disability benefits. Mr. Green's monthly, they're calculated at $326. Mr. Green informed me that due to his incarceration, those Social Security benefits have since stopped. But I do not have any documentation to support that, Your Honor.
Okay. Well, what we're going to have to do then, Mr. Vanderhorst, the court will enter the order as submitted, and then what you can do is at that point file a motion for again the appropriate I guess you'd say obviously there wouldn't be any credit, because if he's not getting it then there would be a credit, but I guess I'll leave that up to you as to filing the appropriate motion in this matter, Mr. Vanderhorst.
Thank you, Your Honor.
Okay. Court will conclude this matter at 9:10 a.m. This matter is before the court on the defendant's motion to show cause and to hold the plaintiff in contempt. The court would note that it is now 9:11 a.m. The matter was set for 9 o'clock. The plaintiff has not responded, not filed any pleadings, and is not present currently in this matter. Mr. Todd.
Thank you, Your Honor. Your Honor, Ms. Hayek does have a confidential address. We looked and found what we believe are her 3 most recent addresses and sent the notice at all 3 locations. The judgment grants Mr. Bozo parenting time of 1 weekend a month.
Mr. Todd, if I don't want to interrupt you, but on this, obviously with a confidential address, there's a way to send that to the clerk, and then the clerk would get that served.
We tried to do that, and they said they wouldn't.
Okay. Well, I'll have to check into that. It used to be the procedure, and
that's what I thought.
Okay, go ahead, Mr. Todd.
So Mr. Bozo is entitled to 1 weekend a month, alternating holidays, half the summer vacation period, a neutral pickup location. Mr. Bozo does live in Florida, and so the parties agreed previously to equally split the cost. Mr. Bozo has been unable to see the child since 2020 and has no contact since 2020. He's tried to contact the plaintiff and has had no response. So we're respectfully requesting plaintiff be held in contempt and require plaintiff to promptly allow parenting time and award makeup parenting time. We believe an appropriate result would be the full summer 2023 parenting time. And we are requesting attorney fees for having to file this motion.
Okay. Well, the court will look into that issue on the, did you get where you sent it to the last 3 addresses? Did those all come back?
Only 1 came back. So I assume one of the other, the other 2 went through. So
Okay, well, what the court will do in this matter, the court will grant your requested relief by default, the plaintiff not appearing in this matter. What I'm going to do is for the summer, we'll allow him to have the summer, the entire summer as makeup, except for commencing 1 week after school vacation starts and ending 1 week before the commencement of school. And the court will grant your request for attorney fees as well. And I guess if Ms. Huck should ever proceed in this matter, we'll address things at that time.
Absolutely. Thank you, Your Honor.
Okay, you can submit under 7 day.
Thank you, Your Honor. Oh, I guess 7 day, just probably include it to all the 3 of those addresses still.
Yes, why don't we, well, don't send it to the one that it came back from because we know that you, but send it to the other 2.
Yep, absolutely.
Okay. Thank
you, Your Honor.
you. Court will end this matter at 9:15 a.m. Court will note that Ms. Huck is still not appeared. Defendant's notice for presentment of order. Mr. Bostrader, have you had any communication from the plaintiff in this matter?
No.
Okay. Court will note that it is now 9:16 a.m. The matter was set for 9 o'clock a.m. The plaintiff has not appeared, nor has the plaintiff filed any pleadings in this matter. As a result, the court will enter the order as submitted by defendant in this matter. That will conclude the case, and Mr. Bostrader, we'll get that order entered, and you can get that anytime you wish from the clerk's office. Court will note the appearance of Ms. Reed on behalf of plaintiff. Thank you. Is it Galza on behalf of the defendant?
Miss Glaza, Your Honor.
What was, I'm sorry?
Glaza.
Glaze, I'm sorry.
That's all right.
This matter is before the court on the plaintiff's motion to modify parenting time. I do note that the court has reviewed the pleadings in this matter, which includes the answer as well. Ms. Reed, have you reviewed the answer?
Yes, I have, Your Honor.
Okay. As the defendant's not objecting to meeting at the sheriff's office, go ahead with the rest of your motion, Ms. Reed.
Your Honor, my client's requesting that parenting time for the plaintiff be modified to what the parties have been doing for the last 6 months, which is alternating Friday to Sunday at 6:30 as the child is in school. And my client, under the judgment of divorce, has primary physical custody, even though it says close to equal parenting time. The plaintiff has not been exercising. I'm sorry, no, she's the defendant. The defendant has not been exercising that equal parenting time since entry of the judgment. And as I stated, that she has been exercising the Friday to Sunday for approximately 6 months. In response to her answer, all of those allegations are not true. And further, in her response, where it says that my client through counsel agreed to her request of Friday to Tuesday, that is simply not true. And it's a violation of MRE 408 to put any settlement negotiations into pleadings, especially when they're not true. So we are asking that the parenting time be modified to what the parties have been doing, and we're requesting sanctions for the Rule 408 violation.
Okay. Ms. Glazer?
Thank you, Your Honor. I submitted my response in addition to a brief and support requesting a little bit of an alternate parenting time arrangement. The judgment of divorce does order that the parents share close to equal parenting time as possible, taking into account the work schedules of the parties and the schedule of the minor child. For the past 6 months, which has been basically the school year, Miss Rill has been having parenting time Thursday through Monday. In February, Miss Rill's schedule changed. She notified plaintiff that her schedule was changing, and she wanted to just shift it from Thursday, Monday till Friday through Tuesday. Since February, the defendant has been getting her son on Friday and dropping him off on Monday still to school, even up till today. They just dropped him off at school this morning. So I don't know where plaintiff is getting that she hasn't been exercising equal or close to equal parenting time. During the summer months, this past summer and every summer since, she has been alternating week on, week off with the minor child, which is the reason why we are asking here today to deny plaintiff's motion to drastically cut short defendant's parenting time and ask that it be just shifted instead of Thursday to Monday, Friday through Tuesday, but also that be every Friday through Tuesday to be consistent with the summer scheduled parenting time. The reason for this is Sebastian, the minor child, is 8 years old. He's going to be 9 in July. Defendant has been highly involved in his upbringing, schooling, extracurricular activities, and appointments. She goes to every parent-teacher conference, including the one that just occurred March 22nd. She did the parent-teacher conference via phone. I don't know if plaintiff spoke with the teacher or even attended his own separate parenting teacher conference, but defendant definitely did. She regularly helps him with his homework. She engages, with him to take him to museums and planetariums, parks, and movies with his brother, who lives with defendant. She attends every single one of his medical appointments, whether that be in person or virtually. And while at defendant's home, Sebastian, shares a residence with not only his mother, but his stepfather and half brother. They share a bedroom. There are tons of kids in the neighborhood. Sebastian's best friend, Dylan, he's known over 3 years, actually lives right across the street. Because of his developing age, he started to develop deeper relationships with his peers and a definitely deeper relationship with his brother. And Ms. Rill only wants to do what's best for him. We do believe that it's in the best interest of Sebastian to modify the parenting agreement, but to modify it from Friday through Tuesday, but make that every week rather than every other. She already has them every week in the summer months.
Okay. I assume, Ms. Reed, that's not acceptable to you.
That is not acceptable, Your Honor. That's not a request for a change in parenting time. That's a request for change in custody, as then it would shift custody to primarily with Ms. Rill, as she would have every week from what she's requesting. And that would leave my client for 2 to 3 overnights per week. So that's not a change in parenting time. That's a shift in physical custody.
Okay.
May I respond?
No, what the court's going to do is the court's going to refer the matter to the referee for a hearing on parenting time. There is no issue of custody again, before the court. So the court will refer the matter of parenting time and we'll have a hearing and can basically filter everything out at that time. So that will be the order of the court. We'll end this matter at 9 on behalf of the plaintiff, Ms. Canfield, on behalf of the defendant. This matter is before the court on 2 motions of the defendant. The motion for a parental alienation assessment, appointment of a GAL, as well as to cease counseling and for contempt. Ms. Canfield, I asked you before we start, what's happened to the DHHS investigation?
My understanding of the DHHS investigation quite some time ago is that there may have been a substantiation that father had left a bruise on Abby while trying to pull her away from running to the traffic. But that my understanding was that there were no services and there was no open abuse neglect case at that point in time.
Okay.
My client was given the supervised parenting time by this court, which according obviously to the motion has not occurred consistently or even as ordered by the court. And I can inform the court that with respect to part of one of the motions, Ms. McNiffen, we lost my client.
There he is.
Okay. Are you all right, Mr. Schmidt? Are you having bad service, sir?
He's muted.
Can you unmute yourself?
Yes, I'm sorry. I think I lost service. I'm okay now, though.
All right. Thank you.
Thank you.
So with respect to the appointment of a guardian ad litem, Ms. McNiff and myself did agree that Anya Henderson would be the appointed guardian ad litem. Ms. Henderson was willing to take that appointment, and that did occur before at the hearing before referee Larry Snyder on April 5th of 2023. So that portion has been handled. We would now only need to proceed with the motion regarding the counseling and the contempt, as well as the parental alienation assessment. Now, Ms. McNiff and myself did talk about this at the last hearing. I've spoken with my client. If the court is willing to do so, I think we can take these off of your docket and have everything heard in front of referee Snyder. It seems like quite a bit of the testimony that would be put forward in both these motions and what we have pending before referee Snyder at this point regarding the parenting time expansion would be the same witnesses. And I don't really want to have both of you spending time listening to those people when we can really refine it down to perhaps a few days of hearing in front of one of you.
Okay, thank you. Did you have an agreement as to what you're going to do as far as the cost of the GAL?
Yes, we did agree that they would split that cost 50-50.
Okay. So that takes care of that issue. Ms. McNiff, are you agreeable to send the matter to the referee in this case?
I am, Your Honor. Ms. Canfield and I have been discussing this matter and we have come to some agreements. I think that due to our diligent efforts, we have calmed things down as well between the parties. But I think it does make good sense to conserve on judicial time by only having hearings with referee Snyder. And I do think that we'll be able to come to an agreement too regarding an assessment for parental alienation and perhaps psych evals too. We have some ideas on that.
Okay, well, the court doesn't want to interfere in that. I'll let you, again, you work that out and see if you can't come to a resolution. If not, you can always bring the matter back before the court.
Thank you, Your Honor.
Okay, thank you. We'll just do a referral over to the referee.
Defendant, he is attending via telephone.
Okay. Court will note this matter is before the court on the defendant's motion to terminate the personal protective order. What we're going to do is potentially take testimony from both of the parties. Okay. Ms. Wickham, you can proceed.
Thank you, Your Honor. I'd like to start with my client, Lewis Adams, please.
Thank you.
Okay.
And Mr. Adams, you are the respondent in this case, and you filed this motion to terminate the personal protection order. Is that correct?
Yes.
Let me start first by asking you, how did you find out that there was this personal protection order against you with your wife, Brittany Adams?
I found out, I got a letter in the mail saying to surrender my CPO.
Okay. And did that prompt you to go to the circuit court clerk's office to ask about any personal protection order against you?
Yes.
Do you recall the date that you were served with the personal protection order?
The date, no, I was served the day before our custody hearing.
Okay, so would that be the business day before?
Yes.
Okay, and you had a motion hearing in your custody or divorce matter on March 13th, is that correct?
Yes.
So do you believe that you were served with this PPO on March 10th then? That would have been that Friday before?
Yes.
And who served you with that PPO?
Brittany Adams' friend, Taylor.
Okay, and is it your understanding that this PPO was issued on February 14th?
Yes.
Between February 14th and March 10th, did you continue to have contact with Miss Adams?
Yes.
And was that for child-related matters?
Yes.
Did she at any point tell you that there was a personal protection order that she had requested of the court?
No.
At all times, was that contact peaceable?
Yes.
There was absolutely zero assaultive or threatening behavior towards her?
No, there wasn't.
Does Miss Adams know where you live?
Yes.
Is that in fact in the marital home?
Yes.
And is she also aware of where you work and what your work schedule is?
Yes.
Did she at any point attempt to serve you previous to being served on March 10th?
No.
Okay. And again, you were made aware because you were requested to surrender your CPL, is that correct?
Yes.
All right. Sir, turning to the verified statement that Ms. Adams had attached to her request for a personal protection order, she lists 5 separate incidents, and I'm going to go through them with you. You responded to a few of them, but let's start with the January of 2022 incident. Do you recall the statements she made in her verified statement?
Yes.
And do you recall the answer that you filed?
Yes.
Do you have anything to supplement the court with regards to the answer to that incident?
No.
Okay. If she stated that you had come into her room mad at her, is that in fact false?
Yes, ma'am.
And she had in fact been out drinking the entire night before?
I can't tell you she was drinking the entire night, but when she got home from her party, I could tell that she had been drinking or under the influence of something.
Okay. And you in fact stated that you smelled alcohol on her breath?
I did.
And you said you also inspected her pupils because she had previously had a substance use issue and you were able to tell if she was under the influence by looking at her pupils?
Yes,
And that's something that you were able to do over the number of years that she had her substance use during your marriage?
yes. I began to learn about her mannerisms when she was under the influence.
Okay. So in fact, you don't believe she was in any position to be able to recall any incident that happened January 2022, the date to which she's referring?
No, I don't.
Okay. Was she in fact driving your father's vehicle?
Yes,
And she in fact, due to her absence from the home, caused you to have to call into work?
yes.
Okay. With regards to the incident that she's referring to as the spring of 2020 incident, do you recall what she put in her verified statement?
I'm looking at it, yeah.
Okay. With regards to that incident, were you in her face yelling at her or poking her in her chest?
I was upset. My voice was raised, but I wasn't poking her. No.
Okay. Did you in fact grab her arm and throw her on the bed?
No, we weren't even in the bed. We never made it to the bedroom. That's a lie.
Okay. Do you recall the incidents that led up to that particular instance she is referring to?
Yes.
And what was going on right before she says all of these things happened?
As far as, okay, so the day before, I got home from work and she was, getting ready. And I asked her, are we going somewhere or whatever? I don't remember the exact words, but I aired to, what's going on. And she said her girlfriends called her and said there was I believe it was a birthday party. And she was going and she'd be home, between 11 and 12 o'clock or whatever. I had worked, I believe I worked a 12-hour shift that day.
Okay,
So,
and we're talking, Mr. Adams, I want to make sure we're talking about the correct incident. This happened, she's saying something happened in the spring of 2020. The very next incident that she's referring to, not the January of 2022, the spring of 2020.
Oh, spring, okay.
Yep.
Okay, hold on, I'm sorry.
That's okay. Regarding that particular incident, do you know what was going on between you two prior to what she says happened?
No, like none of this makes any sense.
Okay, so Mr.
No,
Adams.
I don't.
Okay, you don't remember? All right. So you've had a chance to read those allegations. You indicated that you were yelling at her, but at no point did you put your hands on her?
No.
Okay. Did you at all threaten her life and say you wish she was dead?
No.
Okay. Flipping then, sir, to the August of 2019 incident, that would be on the second page of her verified statement. Do you have that in front of you?
Okay. Yes, I do. Sorry.
Thank you. That's okay. So, Mr. Adams, have you had an opportunity to read those allegations?
Yes.
Did you, in fact, charge her up against a wall and choke her?
No.
Okay. Did you, in fact, hold her down and call her all of those names she's saying that you called her?
I don't recall. We were yelling at each other. I don't recall calling her all this stuff. I was angry, though.
Did you start breaking things and throwing her phone at her head?
No.
Did you put any holes in the walls?
No.
Okay. Regarding the November 2018 incident, are you with me on that page on the verified statement, page 2?
Yeah. Yes.
Have you had a chance to read that allegation?
Yes.
Did you, in fact, show up to where she was staying?
Where she was staying?
Yep, she alleges that you showed up to where it says we were staying and Lewis was in our room talking bad about me, calling me worthless.
I do recall this.
Okay, you
Yes.
recall this incident? Do you recall saying that?
I may have said that, but there's a whole lot of things that are not in the statement.
Okay. Did you kick her from behind?
No,
Did you at all physically assault her during that incident?
no.
What were you guys having an argument about where you may have called her worthless?
I found out from her friend Harley had told me that she was cheating on me with James Guy, and I had found out about it and spoke with him, and he admitted it. So I would, it's just another time she found a reason to sleep with somebody else behind my back.
So you were in fact upset that she was not being true to your marital vows?
Yes.
Okay, but at no time did you physically assault her or threaten her life because of that?
No, I don't know why she would not have called the police if I did all that.
Okay. She indicates that the police were contacted. Did you have any police contact on that day?
I don't remember.
Okay.
2018.
Okay. All right. So suffice to say, you just don't remember?
No.
Okay. Regarding the August of 2010 incident, have you had an opportunity to review the allegation that she has written in her verified statement?
Yes.
And on this particular incident, do you recall what she's referring to?
Yes.
Were you in fact drinking on that day?
Yes.
Did you in fact chase her into the apartment and start punching her in her stomach and sides?
No.
Did you punch her in her arms?
No.
Did you choke her and say that you were going to kill her and the baby?
No.
Did you in fact have any sort of police contact on that day?
Yes.
What was the result of that police contact?
I really don't remember.
Okay.
I don't remember.
Okay. Do you have any sort of criminal charges? I'm sorry, or do you have a conviction for that incident?
No.
Okay. Regarding all of these incidents, she's listing the most recent one as January of 2022. Is that correct?
Yes.
Okay. And when, sir, did you in fact file for divorce?
January something. I don't remember.
Of this year?
No, December. It was December of last year.
Okay. And have you, since separating from Miss Adams, had any sort of assaultive behavior?
No, absolutely not.
Has she been assaultive towards you?
No. Since the divorce?
Correct.
Or no.
And have you guys been able to have child exchanges for parenting time without incident?
Yes.
When did Miss Adams leave the marital home, if you remember?
I don't remember the day. All I remember is that you gotta understand this is all very stressful. So, but I know I came home from working the double shift and my house was trashed and empty. Everyone was gone.
Okay. Mr. Adams, is there anything else that you would like the court to be aware of with regards to your request to terminate the personal protection order?
As far as all the times she's assaulted me, or
Well,
I guess I don't understand what you're asking me.
Yep. So Mr. Adams, let me ask you this. We've talked a lot about Miss Adams accusing you of physically assaulting her. Has Miss Adams throughout your marriage been physically assaultive towards you?
Yes.
And I know it may be hard to recall the number of incidents or that you may not have kept track of them. But when you think about your marriage and the physical assaults by Miss Adams, how would you characterize the number of them?
More than
More than 5, less than 10, somewhere in there.
All right. And did in fact, throughout your marriage, you guys have a lot of strife because of her actions?
Yes.
And did they have to do a lot with her substance use, that being drugs or alcohol, and her fidelity?
Yes.
Okay. Thank you, Your Honor. I have no further questions.
Okay. Ms. Adams, do you have any questions of Mr. Adams? You have to unmute.
No, sir, I have no questions.
Okay. That's fine. Ms. Adams, what would you like to tell me?
I would like to say that first of all, the allegations I had written down and put in the paperwork for my verified statement are all 100% true. I have an audio recording of the incident as of January. I have an hour-long audio, which I showed to the police officer, which is why he was arrested that day, where he clearly says, "I will kill you," in the audio. As for the second incident, spring, sorry, there was no police contact on that one. And as for the last one, he did go to jail when he hit me when I was pregnant. He was arrested and his mother bailed him out. The reason there was never any charges pressed is because he threatened me that if I followed through on the charges, that I would pay for it. I also have multiple police reports and I have multiple witnesses along with, and I don't want to ever have to do this, but my children have witnessed him put his hands on me more than 5 times.
Okay.
I'm doing this for the safety of myself, and he's concerned with his guns. He called me the day he got that letter and said, "I can't believe you got a PPO on me, and now I have to get rid of my guns."
Anything else you'd like me to be aware of, ma'am?
No, sir.
Okay. Ms. Wickham, any questions for petitioner?
I have no questions for her. Thank you.
Okay. Okay, I guess any, Ms. Wickham, any additional witnesses?
I have no additional witnesses. I would be comfortable now moving to closing arguments.
Okay. Ms. Adams, do you have any witnesses?
Not at this time, no.
Okay. Okay, Ms. Wickham, any closing argument?
Yes, thank you, Your Honor. With this motion to terminate the personal protection order, my client has testified that these incidents are taken out of proportion, added additional convenient details. And what I would like Your Honor to note is the similarity or the timing with which this PPO was filed and served. Your Honor is aware of the divorce case between the parties that is in docket 2022-3374-DM. The divorce was served on Miss Adams on January 5th. The answer was filed by her counsel on January 24th. Our office, through Ms. Podolsky, did file a motion for temporary custody. We signed that on February 7th. The defendant's answer, that being Miss Adams in that matter, her answer to the motion was signed on February 14th. If Your Honor takes a look at the verified statement, February 14th is the date that is on the verified statement. The timing with which the answer and the contents of the answer in the divorce case to that motion, alleging that our client is physically abusive with the request for the personal protection order, as well as the timing of the PPO being served. The fact that the PPO was in existence for almost an entire month. If Miss Adams felt the need to have an ex parte motion request for a personal protection order, that she was so clearly afraid for her physical safety, for her life, for fear of being harmed from our client, she certainly would not have waited almost an entire month and then served him the last business day, if you will, before the motion hearing on Mr. Adams' motion for temporary custody support and parenting time, which occurred on March 13th. He was served on March 10th. They continued to have contact throughout that time. She does not list any incident any newer than January of 2022. If Miss Adams had any sort of evidence or witnesses, today was the date and time that she needed to bring that. We had given her plenty of time and notice with regards to the hearing being today. So, Your Honor, she had a sufficient number of days with which she could have prepared, brought the evidence that is necessary, and any witnesses I would ask Your Honor to consider heavily the timing with which the request for the PPO, her answer in the divorce case, the hopes that it would bolster your decision with regards to the custody support and parenting time issue before you in the divorce matter, and as well as the significant delay in an ex parte order for a PPO, which Your Honor is well aware of, is to protect her. If she had that genuine concern and fear, knowing where he lives, the marital home, knowing his work schedule and where he is, she had her friend serve him on March 10th when she had an order since March 14th. Thank you, Your Honor.
Okay, thank you. Ms. Adams, would you like to make any statement at this point, argument?
I would just like to say, if I didn't know I needed to have all my proof today, or I would have most definitely had it. The reason it took so long to get him served is because the 3 times I had someone go to his work, they made a joke out of it and would not call him down to the front desk where he works. You cannot just go in there. You have to go to the front office. It is a big building. You can't just go in there and see whoever you want. The 3 people that I had tried to go to his house, I should have done it a different way. I wasn't sure. I've never had to have a PPO before. They were scared and decided as they went to his house, they didn't want to do it. I finally found someone to do it, and it was my best friend, yes. And it was because she was afraid for me. So she went and did it for me because it needed to be done. I had tried on multiple occasions to have him served, and it just didn't happen. As for the evidence, I did not know I should have had all of that here today with me, but I do have every bit of that evidence, including the entire hour-long audio of him threatening to kill me.
Okay. Anything else, ma'am?
I'm not going to disagree that we've been communicable with the kids and the transport of the kids. We've been trying to keep our nonsense away from them as we should. So we both have always made it pretty easy when we have to be around the kids. I think that's it. I'm sorry.
Okay. Anything else, Ms. Wickham?
What I'll say, Your Honor, is that if she had such difficulty serving him, it's my understanding that she could have had a sheriff's officer, deputy, serve him. I believe that the PPO coordinator generally requests whether or not they need assistance serving. So I'm not sure I put much stock into the fact that she had difficulty serving him. I do believe that it was a calculated process of service and that she had ample opportunity to do it.
Okay, thank you. Well, in this matter, the court's again looked at all the pleadings, also has heard the testimony today. Somewhat, again, I guess you say difficult because we have Ms. Adams is not represented. She had a right to be so. She just chose not to. And again, as a result, she has not presented any witnesses other than her own brief testimony. The court would note that this PPO was entered on February 14, 2023. The most recent event that she alleges occurred was on January of 2022, more than a year prior to this issuance of the personal protective order. The court does have the ability to and can enjoin or restrain certain conduct if the court determines there's reasonable cause to believe that an individual has committed or commit any of the acts listed under MCL 600.2950 parens 1A through K in this particular matter. There is allegations of those, but the court would note, again, the most recent was in January of 2022. The plaintiff or petitioner alleges that, again, some of these instances occurred where there was some physical assault. The defendant respondent denies that there was any physical assault in this matter. As the court would note, since the entry of this in February of 2023, the parties have had regular communication. They've exchanged child or children in this matter without incident. The court does note that the PPO entered in this matter simply restrained and enjoined the respondent from entering upon the property where she lives or assaulting her or threatening to assault or injure her in this case. The court does note, however, that, again, the court is troubled by the fact that the most recent events were more than 14 months prior to the filing of the petition, and that petition was filed immediately preceding the filing of the divorce action, which is suspect in this particular case. As a result, in this matter, the court does not believe and does not have reasonable cause to believe that the individual committed or may commit those events. The court is going to grant the petition to terminate the personal protective order at this time. I will inform you, ma'am, in this matter, that doesn't mean that should the respondent take action in the future, you always have a right to file a additional petition in this matter, alleging whatever has occurred in this particular case since that date. But the court does believe that parties have been getting along amiably in this matter. And as a result, the court is going to terminate the personal protective order. With that, the court will conclude this matter at 11:30 a.m. You're free to go. Have a good day. Of Mr. Magnuson on behalf of the prosecutor's office in this matter. This matter is before the court on the defendant's motion to determine child born out of wedlock, seeking a DNA testing in this matter. Ms. Labine, are you opposed to DNA testing?
No, I just think it's pointless. I mean, we both knew that she wasn't his, so, but.
Okay. Mr. Magnuson, what's your position?
If I could just inquire of Ms. Labine, you do know the identity of the who you believe to be the biological father, is that correct?
Yeah.
Okay. And do you know if that individual is willing to cooperate as far as genetic testing?
I don't know. I mean, I feel like he would be. It's just kind of difficult because he's in the military, so I never really know where he's at, and he never, so I tried to get in the beginning, and he was for it and wasn't for it. So
okay, you would be willing to assist us in basically identifying that person and locating them?
Yeah.
Okay, and of course you'd be willing to cooperate?
Yeah.
Okay. Thank you. I have nothing further.
Okay, thank you. Sir, what do you have?
I have actually been in contact with the child's presumed biological father. He said to me that he is willing to be a part of his child's life, and he told me to let him know when I get things situated to further.
Okay. Mr. Magnuson, if we did an order just saying that all the parties would cooperate in testing, would that be sufficient for what you need to proceed against the alleged father in this case?
It would, yes. I mean, if we had an order for genetic testing, that would, I guess we could start from there and then go from there to exclude Mr. Rowe in this case.
I just thought if we were able to do the testing with the alleged father,
that would be fine.
Might be a moot point then to have Mr. Rowe tested.
That would, if we could do that, Your Honor, that would be perfectly fine.
Okay. Mr. Rowe, what the court's going to ask, the court will, based upon the fact that the plaintiff has no objection, would order that, again, you do an order for genetic testing, and in that order put that, again, the plaintiff, yourself, and the alleged father would all cooperate for purposes of that testing, and then Mr. Magnuson can proceed against the alleged father in this particular case. Okay, hold on.
I mean, send it to you.
Okay.
So I need to.
Well, we have an order, but it hadn't been sent to me yet, so that's.
I will send it to you, right?
Well, Mr. Rowe, I have an order, but it's a blank order. So what is the name of the alleged father?
Tyler Ellis.
Do you have a middle name for Mr. Ellis or not?
I'm not sure.
Okay. Ms. Labine, do you have a middle name?
I don't know what his middle name is either.
Okay. Well, we will put that in the order that, again, that Mr. Ellis would cooperate as well, and then we'll have to proceed in that matter. The court will further, I'll put under other in this matter, the court will stay enforcement of the current UCSO pending further hearing in this matter. Okay. That will be the order of the court. That will conclude this matter. Best of luck, and we will be back in touch with you when again as the case proceeds.
Family
Okay.
Blankenship. It is Monday, April 17th, 2023 at 11:31 a.m. Attorney Jennifer Reed represents petitioner plaintiff.
Ms. Reed, just to check in this matter, court does note that in this matter, your client was not served in sufficient time for this hearing, but it's my understanding that you wish to proceed notwithstanding that. Is that correct, and waive the time frame?
That is correct.
Ms. Blankenship, this is your petition, so you give any testimony first in this matter. So, ma'am, you can testify as to what you would like me to be aware of.
The stuff that is worded in this PPO is lies. I am not violent towards him. It's just I want a motion to cancel this against me because there's no reason for this to be happening or to waste your guys' time at this point. I have not been violent with him. I have not threatened him. I am not a violent person.
Okay.
I just want my belongings and to get it over with. That's it.
Ma'am, is there another case proceeding in this particular matter?
Not that I'm aware of.
Okay. Well, if there is, or you can file if your thought is I'm seeking again to acquire property from him, you can file another action and then you can get a order which would grant you access to pick up that property. You understand?
Okay, I did not know how to go about any of this, so I did hire a lawyer to help me with it because I was told that I couldn't do anything with my belongings until I did this meeting today.
Okay.
So that's why I'm here today, so I can try to do something to resolve the problem. I do have a voicemail that Bill wanted me to let him know a time so I could have him and my son Timothy hook up the truck and trailer to bring me my things or to pick them up.
Okay.
So if I'm that violent or to him, why is he calling me and giving me permission to come and get my things?
Okay. Anything else that you'd like to tell me, ma'am?
It's just lies. I've never harmed him in any way. I've been with him 27 years and never. But he also has a Ford Flex that's in my name. I need to know if I can get possession of it so I can either make the payments or figure out how I'm going to pay for this car.
Okay.
But other than that, no, I just want my things.
Okay. Ms. Reed, do you have any questions of the respondent?
I do. Ms. Blankenship, in your motion, you stated that you did not have any contact with Bill until 3/17/23. Is that correct?
I want to say that was correct. I might be off on the date just because it's kind of a mess with all the dates right now. I know approximately from the 13th through is when all this started, and I just can't remember exact dates of when we actually last communicated. And I do know we were in front of a sister.
You did have police contact at the address in Battle Creek on the 15th of March. Is that correct?
Correct.
And so you were at Bill's house on that date?
I was at our house on that date.
Okay, and the police arrived?
Yes, they did.
And did they inform you that there was a civil dispute between you and they offered you options?
They told me that I could leave. All I wanted to do was leave. I came into my home to get warm because I'd already done slept in my car because he threw me out of the house. So I was in there. When he come home at 5 a.m, he tried to talk to me and I said I was tired, I was cold, I didn't want to deal with it. Then I went to leave. That's when he demanded the deed to our home and would not let me in my car.
Okay, I have no further questions.
That's when the cops were called.
Okay.
I'm sorry.
Okay. Anything else, ma'am, that you would like to inform me of?
No.
Okay. Ms. Reed, well, I guess Ms. Blankenship, do you have any other witnesses?
Not with me. I didn't know I needed witnesses. That's why I contacted a lawyer. I just haven't talked to him today yet. I don't even know what I'm doing right now.
Okay. Ms. Reed, do you have any witnesses?
I'd like to call Mr. Blankenship, but for the court's information, a divorce between the parties had been filed in case number 2023-867-DM, and I do believe those pleadings are out for service.
Okay, go ahead.
Mr. Blankenship, do you recall filing a petition for a protective order?
Yes, I do.
And when was the first incident?
I want to say it was at my house on the 15th.
Okay, and is that referenced in your petition?
Yes.
And what day is it listed in your petition as?
Is the 17th.
Okay, and you got those dates mixed up?
Yes.
What happened on the 15th?
I tried to stop her from leaving. She bumped me with her car, threatened to kill me, and tore off.
Did she physically touch you that day?
She pushed me to get into her car, to get out of her way. She pushed me to get into her car. And then I stood by her car because there was a car in front of her. She couldn't get out. That's when she backed into me and left.
Okay, and how many, was it once that she threatened to kill you, or was it multiple times?
It's been more than once.
On that specific day?
No, on that day, I think it was just the one time.
Okay, and was there any other incidences?
Just anytime. There was one time she was like hiding in a parking lot up the street at next to Dollar General, and I went up there and she screamed at me, told me to get out of her face or she'd kill me then.
And when was that?
That was a couple weeks before this all started.
Okay. Has she told you that anyone else is going to be hurting you?
And she said she had, in her words, was she had somebody that would do, she had somebody to take care of.
And when did she say that?
That was the last phone conversation we had. I can't remember the exact date.
Okay, and have you had any contact with her since the PPO was issued?
No, ma'am.
Okay, and she had stated that you were leaving her messages or were trying to coordinate a time for her to pick up her belongings. Is that true?
Not with her, only through her children.
Okay. And are you still afraid for your safety?
Yeah, as a matter of fact, past 2 weekends in a row, I've had people pounding on my walls and windows of my house. Last weekend, I called the police twice. This just happened again Saturday morning at 4:00 a.m. I didn't call him this time. The oldest boy was there and he went out, but it didn't happen again since.
Okay, but you don't have any information that it's Mrs. Blankenship doing that?
No.
Has this pounding, knocking occurred before?
No.
Okay. Are you requesting that this PPO remain in place?
Yeah.
And why?
Because she's unstable. I don't trust her. I mean, I'm scared of her.
Okay. Is there anything else you'd like the court to know?
No, but she has put her hands on me before. My kids have seen it.
Okay. And is that recently?
No, that's been a while. That's a few years.
Okay, I have no further questions.
Okay. Okay, Ms. Blankenship, do you have any questions of the petitioner?
I do. He says that he had no contact with me, but my voicemails here on 3/17/23, that's when he also called me and asked me if I could let him know a time to pick up my belongings.
Okay, ma'am, this is your time to ask a question, not to give a narrative.
Okay, sorry. I don't.
Okay.
I have no questions.
Okay. Any other witnesses, Ms. Reed?
No, Your Honor.
Okay. Closing argument, Ms. Reed?
Your Honor, my client wishes that this PPO would remain in place. He is fearful of the respondent. She has threatened to kill him on multiple occasions. She's been physically assaultive to him on multiple occasions. She even backed her car into him. So we believe that this PPO is necessary and appropriate, and we're requesting that the respondent's petition or motion be denied.
Okay, thank you. Ms. Blankenship, any closing argument?
No.
Okay. Well, in this matter, the court has heard the testimony as well as reviewed the pleadings in this case, meaning the petition and the respondent's motion in this particular case. The testimony today is that, again, there had been multiple times, as alleged in the petition and the supporting documents, that there have been threats made by the respondent that she would in fact kill the petitioner and or have someone else take care of that. The court does note that the court can grant a personal protective order to enjoin or restrain certain conduct if the court determines there's reasonable cause to believe that the individual has committed or may commit any of the acts listed under MCL 600.2950, parens 1A through K. And obviously, some of those various conditions are assaulting, attacking, bleeding, or beating, molesting, wounding, or again, or threatening to do so. in this particular case. The court has noted that, again, that this personal protective order was entered by Judge Yost Johnson on March 20, 2023, effective for 1 year through the same date on 2024. The court does believe that based upon the testimony that there's reasonable cause to believe that the respondent has or may commit some of those particular acts listed under the statute. As a result, the court is going to deny the motion to terminate at this particular time. I'll let you know, Ms. Blankenship, that the relief you're requesting as it relates to property, that you can have your attorney contact Ms. Reed. You can arrange a time when a third party can pick that up, or we can do it as a result of an order in the divorce proceedings and accomplish that. So you do have a way to accomplish what you want and not have any contact with the petitioner. So that will be the order of the court, and we'll conclude this matter at 11:44 a.m. You're free to go. Have a good afternoon to all of you. Ms. Heckman, as you're the plaintiff, I'll start with you. What issues do you believe to be in dispute in this case?
I'm sorry, I don't understand what you mean.
Well, what are you fighting about?
I just want to get divorced.
Okay. Well, I'll go with Ms. Reed then. Ms. Reed, what issues do you believe are in dispute?
Custody, parenting time, child support, property and debt division.
Okay. Ms. Heckman, are you fighting about spousal support?
I am not.
Okay. And have you done any discovery, Ms. Reed, or?
We're in the process of exchanging the financial disclosures. My client has them almost done, and I haven't received any from the segment yet.
Okay. Are you in need of discovery, do you believe, or not?
I think 60 days would be sufficient.
Okay, well, court will put a June 1st deadline and see if we can't get that taken care of within that time. That'll send the matter to mediation in June. That is where an attorney mediator, again, meets with you and attempts to resolve issues. There is a cost to that, so you should be aware of that. The mediator will contact you about that. Court will set July 17, 2023 as the settlement conference date. Parties are required to be present unless they've come to a full resolution prior to that time. It'll be set for 1:30 p.m. And if you get matters resolved prior to that, then obviously you don't have to appear on that day. Ms. Heckman, you have any questions or anything the court can address?
I don't think so at this time.
Okay. Ms. Reed?
No, Your Honor.
Okay, well, we'll let you go then and conclude this matter at 1:24 p.m. You're free to go. Have a good afternoon.